Well, shifting focus, President Cyril Ramaphosa's signing of the Expropriation Bill into law has triggered widespread controversy. The new law's allowance for land expropriation without compensation has raised fears about property rights, investment and the overall health of the economy. Makone Maja from the South African Institute of Race Relations joins us to provide more insight. Thank you so much for your time, Makone. Now, just lay the table for us on what powers this law gives and to whom.
Thank you so much, Zinati, for having me. I think, that is an excellent question. This bill is a mechanism of giving government enormous amounts of power to basically expropriate property. There are various reasons under which property can be expropriated, but largely it must be for public interest and public benefit. I think there's been a lot of conversation on the specific bill and the controversy it poses on whether this is an instrument or an adequate mechanism for land reform. The department under which this bill falls and the minister who administers over this bill gives us an indication, right? Because we have a Department of Rural Land and Rural Government and Land Reform, and we also have a Department of Public Works, which is more about like administrative functions of municipalities. And given that this bill falls under the former, the Public Works Department, I think that gives us an indication on whether this bill aims to deal with the conversation or with the aims of land reform, even though there are elements of this bill that implies that it does. We argue that this gives the government unconstitutional power to expropriate properties of South Africans. We make these arguments on two bases. One are the substantive grounds on which the bill is unconstitutional. So that relates specifically to the content of the bill, the things the bill says that the government should do and the processes that the government should take in expropriating property. The second reason for arguing on that this bill is unconstitutional relates to procedural reasons. That element is about the manner in which the bill was brought to assent. Basically, the legislative processes that were undertaken to bring this bill into law. We argue that there are various elements in that process that basically steamrolled through many rights South Africans have in exercising their right to be heard during public hearings as a part of those legislative processes that the government conducts in order to garner public submissions and public presentations on their positions on the bill. So those are the two fronts on which we argue that the bill is unconstitutional. The bill is far-reaching, and so it requires that during this interview we go in greater depth in explaining exactly which clauses in the bill or which elements of the Constitution this bill assaults. And so that's very much a part of the conversation that we have to have here, so that we unpack for the audience what the Institute's issues with the bill are on the constitutional front, and then maybe we can get into its impact on the economy and South Africa at large, which is equally as important.
Well, let's actually get into that, because I think for me, I felt that a lot of the opposition was maybe on certain elements of the bill. But actually, it seems that just even the bill holistically is just seen as, just completely inappropriate, I guess. So just walk me through, the first one where the bill is unconstitutional. Where would, amendments have to be made there or remedies there going forward?
Yeah, so Zinati, the unconstitutionality of the bill, we argue on substantive grounds, relates to certain clauses within the bill. And I take your observation in the beginning, and I want to preface that whilst we can only get into certain parts of the discussion about the bill, it's very hard to give a full overview of the bill. And we recommend that people go to the Institute of Race Relations' website, use the search function and search for the submissions that the Institute has made with respect to this bill. We have been part of the public hearings on the bill since 2013 and have challenged each iteration of the Expropriation Bill from the 2013 version to the act that we now have on our books. So I do also want to preface and say that when you hear certain elements of the bill that are unconstitutional, you kind of have to wait for the entire case to be made so that you get a full grasp, like you alluded to in the beginning, so that you get a full grasp of the many ways in which this bill empowers the government and accumulates untrammeled amounts of power in the government's hands against people who are targeted for expropriation without compensation. So let's get into the discussion about the elements of unconstitutionality. Substantive grounds, the things that the bill says that go against the Constitution, principles of the Constitution and clauses of the Constitution. I'm going to speak, for example, about the definition that the bill uses for expropriation, right? So expropriation is defined in the bill as acquisition of property by an expropriating authority, right? That this acquisition is typically at just and equitable compensation.
Yeah.
This definition does not comply with international law standards. And the reason for that is because it does not take into account instances where expropriation takes place owing to state action, but does not comply with the definition of acquisition, right? So there are instances where third parties, for example, can be ordered by the government to exchange property. And since that is not included in the expropriation definition, it leaves people without the constitutional guarantee of just and equitable compensation. So that is one way in which the definition of expropriation is too narrow and does not factor other ways in which expropriation can take place, right? Another way is custodial taking, right? So again, expropriation is where an expropriating authority, typically a municipality, acquires your property, right? But there are also ways in which government can deprive individuals and even businesses of their property, right? So let's say the government approaches you, Zinati. You have a private home and the government wants to use that space on which your home resides. And the government wants to take control of your property, exercise possession and control over that property and deprive you access to it for a period of time. This time can be stipulated, right? They can say maybe for 6 months.
Yeah.
That limited definition of expropriation does not factor that into that action of custodial taking into consideration as a possible expropriation, which means that the government does not owe you compensation in the instance that it implements a custodial taking over your private property.
Yeah.
So there are elements of the bill that limit expropriation to just land, but the bill defines property in terms of Section 25 of the Constitution, which is not just land, and it's certainly not just immovable property. It also includes movable property. But in that example that I gave you of a custodial taking, you can see how you as an individual will have to face an enormously empowered government. And by the way, if that private property that the government now exercises control over is under a loan facility, guess what? You still have to pay for that loan facility without ever getting a cent from the government, despite it having power to deprive you of access to that property. So again, that is simply unfair. And it also creates such an imbalance in the system where the government now has way too much power, sweeping powers to basically take and confiscate people's properties without compensating them. One of the other ways in which it's unconstitutional, staying on the issue of definitions, is on how it defines land, right? There's a vagueness in the definition of land and whether land includes improvements on the land itself, right? So you could have land, say your family owns land, and that land maybe has a Wendy house on it, or you have built a swimming pool on the property, or you have Wendy houses on it, right? You've completed certain improvements on that land. It's not clear from the bill whether that land, right, that can be expropriated without compensation, but now includes your swimming pool, your lapa, your Wendy houses, whether they too fall under the definition of land and can thus be subject to expropriation without compensation. In terms of common law, land does include all improvements attached to the land, and so there's a vagueness that is attached to that. It also contravenes, as you can see, the principle of rule of law. South Africa is a constitutional democracy, and rule of law requires that the Constitution be the supreme law of the country, and that all organs of state be subject and limited by the rules of the Constitution. And here what we're witnessing is the government trying to create a slipway, exceptions, special rules for itself so that it does not have to comply with the Constitution. And so those are some of the grounds on which we oppose the bill on constitutional basis, specifically the substantive reasons, and then also on the processes that were undertaken to bring the bill into law. There are so many elements of the public hearings, legislative processes that were just steamrolled, right, by a government that clearly had an agenda, right, to bring this law in, to bring the bill into law, despite all arguments and all inconsistencies that they were confronted by.
I mean, we definitely could have an hour-long conversation on this because it is a very, very important topic. But unfortunately, we have run out of time. But really just bringing in also a number of issues, considering also the fact that we are under the GNU, where now we could see that unity or friction being tested there. But also quite interesting to see the private sector chipping in as well in terms of how South Africa looks like as an investment destination there. But we will definitely be keeping a very close eye on this. Thank you so much for putting a spotlight on that, Makone. That was Makone Maja, campaign manager at the South African Institute of Race Relations.